know that we are here to know about the intelligence. We are very well aware about the intelligence, emotional intelligence. But today we will discuss artificial intelligence. And with Aishwarya, assistant professor, City University School of Law, give us some insight over the role of artificial intelligence in IPR. So IPR, intellectual property. So it's a combination of both these two words, artificial intelligence and IPR. So now please welcome Ms. Aishwarya Aneja, Assistant Professor, School of Law, City University. Please come on the stage and give some insightful words, impressive, brief introduction and buzz. Okay, thank you, ma'am.
Very good morning to all of you. Right, so the topic is role of artificial intelligence in IPR. Right, the topic might seem it's boring, but it is not. Right, here we are basically here to understand that what is AI and what is IPR. Now, when we talk about artificial intelligence basically refers to it is a field that has come out from computer and it can work like a human. Right? It can totally work what all works a human can do, the same works the AI can do as well. But the topic is with regard to IPR. So basically what we are talking here is whenever you come up with some new invention under IPR we have copyrights, patents, GIs. Right? So in case if you come up with any new book, any new song, so you get a right over it, right? And that right is legally being protected by the intellectual property rights. Now, when for example, if there is AI is there, right? If AI comes with some new tone, right? There is some new versions of photographs created by the AI. So according to you, who shall have the right over that? Because that new thing is coming out of AI. AI is generating that, right? So according to you, who should have those rights over it? This is the major conflict that is there between artificial intelligence and IPR. Are you getting the gist? Why are we studying these two things? Right? When we talk about patents are basically inventions that come up, right? If for example, there is a different kind of fan that comes up, right? That has come through the AI, but who shall have the rights? So when we talk about IPR, we talk about different treaties and conventions as well. So either it is international law or either it is domestic law. No law has clear understanding of what rights will be given to the AI created material. Clear? Now, for example, if you're talking about if that fan is being created, tomorrow that fan, we give a lot of there is kind of a coding that we give to AI and then he comes up with something. So that coding is given by that person itself, right? So that person can say that I should get those rights because I have done that coding. Now the issue comes up, IPR says that IPR rights can only be given to humans. Humans have rights over it. So AI does not come into the picture. So this conflict, recently there was a case in UK. The case basically said that there was a person, he had made a lot of photographs, different kind of photographs all over the world. But that thing was done through AI, but the coding was given by him. So the court held that IPR rights can only be given to citizens, it can only be given to humans. Right? So coming to the presentation although is in regard with each and every right, I hope you might have understood what exactly is AI. The rapid advancement of AI continues to raise complex questions about the applicability of IPR to AI and AI generated works. See, there is a differentiation between what is AI and what is AI generated works. Now, if we are giving any coding to AI, that is any coding to any machine, that is AI. But what comes as the output of that is known as the AI generated works. Right? Secondly, the major issue that is coming up is the new startups. The new startups, see, any human, if you have to come up with something new, so you will apply your brain and it will take time. But AI is doing before that. And because AI is doing before that, so humans are getting affected by AI. We might know, today, drafting is there. For example, we all are lawyers. In the coming times, drafting will be done by AI. So don't you think that, lawyers also, our field also is in a kind of threat at this situation? See, AI might create n number of things. Right now in the movies you might be seeing, whenever you go to watch a movie, after the movie it comes that these songs have been developed by AI. So who is the owner of AI? And if something wrong happens in that, who shall be blamed for that? Are you getting what I'm trying to say? So the need of the hour is basically either it is the Indian law, either it is the international law. Stringent laws have to be made in such a regard which basically says that anything that is being done through the AI, will it get protection or it will not get protection? Now recently AI has been launched, so everybody is working towards it. But with the coming times you will see that people will stop working over that thing just because that AI is taking a lot of people's jobs as well. And AI has a very different complex subject in total. Now in UK there comes a new technology, but that coding has been given in that country to the AI. So do you think that country shall hold some rights over it? It should, but it is not getting those rights. Right? That is why this is a matter of concern, because intellectual property rights are the rights that we get over the creations of our mind. Whenever we come up with something that is a creation of our mind, we get intellectual property right protection over that. The unprecedented pace of development of this technology is pushing enterprises towards self-governance frameworks founded on the ethical consideration. IP remains one of the leading and most continuous issues in respect of AI. Now, rights in input data that is used to train AI models and infringement of AI. See, here we have basically talked about that, AI is creating these issues, a lot of hurdles are being created because of the AI. But do you think that, AI can be helpful as well with regard to IPR? AI can be helpful because there is a lot of infringement that takes place. Right? AI should be trained in such a way, if there is any trademark infringement, AI should work upon that. If there any patent infringement, AI should work upon that. So we cannot conclude by saying that AI is only working on a positive front or only on a negative front. AI can be used on other things as well. But the need of the hour, the reason for having this is basically to understand that yes, at this point of time, we are in such a confusion that anyone who comes up with any invention or with anything that is being covered under the IPR will face a lot of challenges just because of this. Now coming to the input data, training generative AI involves using large bodies of IP protected works in ways that may be infringing under current laws. Governments seeking to unlock the potential of generative AI are now often looking into legislate to permit text and data mining of IP protected data in order to train. Now, for example, there is some coding that has been done, but that coding has already been protected earlier by the IPR. But now we are using that coding to come up with some new AI invention. So again, you will have a lot of infringements that will take place. So one place or the other, either there should be laws made in such a manner to differentiate that what exactly is the role of AI and what exactly is the role of IPR in that. Input data is basically the data that we are getting, the text that we are getting to generate something out of that. Alright, that is what is being referred as input. The intellectual property in the data used to train AI models is growing as a subject of legislative discourse and is now a key issue in matters at flooded courts. It is a highly debated topic whether use of copyright protected materials to train. Now, how many of you have already studied IPR here? You have studied. In case if, for example, I need to get a directory of City University of all the numbers, right? I just collect them and present it in a book. Do you think that I will get copyright protection over that? You got my question? I collect numbers of all the teachers in the City University. I create a directory, I create a book, and I, basically issue it. So do you think that I will get copyright protection over it? That is the sweat of the broad doctrine which says that I will get copyright protection. Because copyright you can also get even if there is minimum creativity, because they say that that is the hard earned labor that you have put in that. Right? Now here comes the AI. See, although this is something that is an exception to the rule of copyright, that is why we have this specific guideline which says, because if I am collecting all the numbers and presenting it in one book, I do not have done anything creative here. but it is my hard earned labor under which I will get a right under the copyright. And there is no confusion, the doctrine has stated this thing very well, right? It is a highly debated topic whether use of copyright protected materials to train AI infringes copyright. Generative AI has spanned a variety of copyright lawsuits around the world. In US, for example, authors and news publishers have sued OpenAI, Microsoft, and others over their language models, alleging their training processes, their outputs involve impressible copying. Now again, see, when we talk about the input data, we can have many input data because copyright protection somewhere or the other is protecting us. But because of the coming of AI and because of the speed of AI that it is coming with, there it creates a confusion between the AI and IPR. Now, rights in output data, AI generated works, AI inventions and AI outputs and infringement. Generative AI, that is AI which generates text, image, speeches, video or even technical inventions based on user input continues to increase in capability and grow in adoption. Generally, IP laws are designed to protect human creations. Most copyrights and patent laws, for example, do not explicitly address AI's role in authorship or inventorship. See, when we talk about the definition of patent, there again comes the word inventorship. Right? Inventor is the person who comes up with something new. Now, they have mentioned even in the definition of a patent, any human that comes up with some new invention. Here, there is no human that we are referring to. AI, they are not referring to as human. And courts of UK and US have even said that since humans are not involved, no IPR protection shall be granted on that basis. So input data was when we were talking about the data and the text. When we talk about the output data, here they are basically mentioning about the authorship or inventorship, which has been mentioned under the definitions of the IPR. If AI is responsible for content creation automatically without any human input, then the question is who owns the copyright of such content? Traditionally, this is the person or organization that creates the work. If there is some organization that is creating some work but using AI, as per now laws, they are not being protected. For Europe, the overwhelming view is that AI cannot be a legitimate author. However, specific ways of using may result in work is protected for this user. Again, all this has been output data. Only see basic focus that we are doing even in the presentation, and even if you see AI and IPR as a large whole is upon copyright. Because there the doctrine of sweat of brow is also there, doctrine of modium of creativity is also there. Coming to the patents and AI generated inventions present similar challenges. Many patent laws require the inventor to be a natural person. Natural person is a requirement which has been given as per the IPR law as well. A requirement which could exclude AI from being independently recognized as an inventor. AI driven innovations such as those involve algorithms and machine learning processes. Now machine learning processes, if anything comes out from a machine, that is a machine learning process. Till date, certain judgments has only been given from the side of US, and those laws say that to any machine where any mechanical labor is there, we are not granting them any right under them. Also, the criteria for patentability usually involves requirements for novelty and inventive step and industrial applicability. These criteria raise questions about whether AI generated inventions can never meet the inventive step requirement. Some jurisdictions have, however, pressed ahead with updating their patent laws, and we accept will accelerate. Indonesia, for example, recently amended their patent law to provide protection for certain inventions in technology that solve specific problems. While software alone is not patentable, AI programs now, since AI is a field that has come out of computers, a lot of softwares can also be created out of them, which softwares might somewhere lead us to something different. But again, if I am coming up with some software, I am creating that software through some machine. But since there is no human intervention, there is no inventorship there, no authorship there, again, I am not getting any rights. So since even I am working and I am not even getting any rights on that, that is why there is a major confusion to deal with, that how should a person who is coming up with something that comes under IPR can be protected. The divergence in approach has caused debate among legal professionals, both academic and practitioners, about the formative patent process, which gives right to the decision of the CIPC. Notably, South Africa's patent approval system follows a formative process which considers the fulfillment of procedural formalities without requiring in-depth evaluations of the prospective patent substantive merits. See here, when we talk about IPR, different jurisdictions have different control over their things. Right? If we are following certain copyright things here, it might be possible that the other country does not abide by those things, because the IPR laws remain to be different in other countries. It is very, very difficult in the coming times to deal with the differences that are arising between the AI and the IPR. AI and digital replicas. A future trend is the increasing focus on the legal implications of deepfakes. As AI technologies continue to evolve, the rise of deepfakes is one of the most concerning developments. A recent report commissioned by MasterCard in New Zealand illustrated the trend. Nearly 29% of the individuals and 18% of the businesses were targeted by the deepfake spams in the past year, and 47 of them failed for the manipulated content. This trend, further fueled by advancement in generative AI, is likely to continue escalating. Same way, if AI is coming with some positive points, it is coming with some negative points as well. Most IP laws are ill-equipped to address the challenges posed by deep fake technology. Copyright law generally is not fit for the purpose in respect of the deep fakes, as the source material for any deepfakes either fails under outside the scope of copyright protection, or copyright owner is not the individual which is being harmed by the infringement. Now, there are certain contractual frameworks relating to IP infringement and AI systems. Liability for infringement also remains an issue despite most contracts between AI system owners and end users dealing with the topic. Even if the court grants that any system who is coming up with some coding, anybody who is coming up with something, he might get a right over that. But if he is getting some right, tomorrow if something wrong happens, will he get sued also for that? The court does not give any straight statement regarding the same. The issue of whether the outputs of AI models, particularly where they substantially reproduce source materials, may infringe copyright, who may be responsible for such infringement, is also unresolved. Is the person who infringed the user of the AI generated work without the right holder's consent, or the AI developer or AI system owner? This ambiguity poses risks for businesses. If there is no clear proprietary right in AI generated works, businesses may be exposed to unnecessary risk, and the case laws, even if we see the outside case laws, this is what is been happening with the businesses as well, just because of not having the stringent laws. For instance, such works could be freely copied by competitors without infringing. Here comes, if we are not giving any protection to the AI, anything that comes out of the AI can be infringed, it can be copied, and since there is no protection, businesses as a whole, people as a whole will face challenge for that. AI and IP management, freedom to operate, sources, infringement risk, mitigation and portfolio optimization. The management of AI into IP practices is expected to become more mainstream in future, freeing up advisors to provide more valuable legal support. AI technology has already been used to improve processes efficiencies for efficient data. See, here just we are talking about in regard to whatever protection we are getting. But in case if you talk about the general trends, you talk about generally. See, AI is also protecting the people's data as well. But that the data that has been created, will that data have any legal protection over that? Just because whatever, even if you check the definition of copyright, you check the of patents, GIs, anywhere, you will always find out that no definition says that any mechanical work that has been done or anywhere where computer has been used, nowhere you are getting protection on that particular thing. Nor till today's date, even the user is also not getting any protection under that. This trend is expected to accelerate in 2025 and now onwards as AI tools improve and our future develop. Now you might be seeing that you have Siri, for example. Right now, if you are giving any instruction to Siri, she is following well and good. In case if she does not follow, if she does something that she is not expected to do, or you have not said, then who is responsible? Do you know about it? Nobody is responsible for that, because that is again something that has been given by AI, and there is nobody responsible even for that. Right? Nevertheless, such AI tools are still in development stages and often still provide an imperfect initial due diligence, which requires subsequent review by a human analyst. AI and IP management, again, freedom to operate searches. AI used in enforcement of, these are the advantages of IP, advantages of having AI. Because till now, if somebody files an application that this was my trademark, this was, I have copyrighted this thing, but again, you have to go through the whole process. You have to understand whether this was already a trademark, whether this has been copyrighted and stuff like that. Right? If we would have AI, then we will just generally search upon that and it will provide us some data over it. IP, litigation and AI, document review and summary. Legal practitioners are already using sophisticated AI tools for reviewing and summarizing large volume of documents. AI tool can quickly scan and summarize large quantities of evidence, identifying the most relevant information for the first hand. Again, they are saying in different fields. For example, we are from law, so again, AI is proving us to be, essential in many things. Drafting is being done. Even, it was being said by the honorable courts as well that now even when we come about argumentation, the preparation of argument, that is something again that can be also done by the AI. Coming to the conclusion, the intellectual property in the data used to train AI models has been the subject to legislative discourse and a key issue in matters that have flooded courts across the world. A highly debated topic is whether use of copyrighted materials to train AI model infringes copyright. Training AI using personal data or protected IP continues to provide a challenge to legislators worldwide. In most countries, authorship of creative works and invention of new technology can only be attributed to humans and can be procured by corporations for work for hire management. Again, the inventive step and novelty in authorships comes into question. A vital question that arises is whether AI can be regarded as a legitimate author of content that it generates or an inventor in case of patents, given the want of legal personality of the AI itself. Persistently, however, the Commission for the IP and Companies in Africa was the first global office to have granted a patent application where AI was the inventor. This move had received considerable backlash from other countries. However, the Hong Kong government has declared AI-generated works as being capable of copyright protection under the existing law. Now, as I told you, different countries have different set of laws. So, as per the Hong Kong, they are saying that anything that is AI-generated works can be protected under the copyright law. The US Patent Office has also issued a nuisance inventorship guidance providing a framework for examiners of patent applications to assess the quantum of human contribution for the invention to qualify for patent protection. In UK as well, the law specifically permits copyright protection in computer generated works through the broader question of originality. Here they are saying that they do protect the computer generated works, but again the question comes of originality in that. Thank you. I hope what all I have told you in just you might be able to understand that. And with the coming times as well, AI is going to play a major role in our lives. So this is something here, our relevance was only with regard to the IPR laws, because IPR laws are somewhere conflicting with the AI models, with the AI and AI generated works. Right? Thank you so much.
If there is any question, please do ask, and the rule applies. Whosoever will ask will get extra attendance. Yes? My A section knows that well, right? So you have to ask the questions, and I believe it was quite an interesting topic and has presented so well. So I request, rather than it's not a request, it's an order, so ask questions. So, should mark you absent because we're mentally absent. Shall we? Nitish, can we have a question from you?
I have a question.
No.
We'll take it from Deva first. Yes.
An interesting session or not? Please don't give me that lame faces. Whether it was interesting or not. See, you all know about Ghibli art? What is Ghibli art? You are generating your pictures from Ghibli art, you are posting it on your Instagram accounts and Snapchats, etc. So my question to you, ma'am, is, see, we are giving access to our photographs on ChatGPT and we are asking it to create it in Ghibli style. So my question is whether that photograph is having right over me, or the ChatGPT is having the right over me, and whether ChatGPT can use it in any other way as far as AI is concerned, because we are giving our permissionary right to ChatGPT, and that ChatGPT out of turning AI can use it in any other illicit manner as well. So ma'am, my question is that how it is justified on this front?
Alright, so we might not be aware, but whenever we download any new application or whenever we do any access to that app itself, it does pop out a message in that, right? We always say it is okay, we allow. And even if you see in iPhone, there are n number of features where they first of all ask you that shall we allow, not allow, sync. Right? So there are different options that they ask. When we talk about Snapchat, if you talk legally, Snapchat has taken right from us and then it is taking our pictures from that. When it comes to AI, now here the topic of discussion says that AI is not taking that photograph because you have already given permission to ChatGPT. ChatGPT is an app in itself which has been created by somebody. So that rights are already there with that person. So we cannot link AI with that because the user, if that user gives those photographs to AI, so that user might be responsible because we have given permission for that.
Questions please, come on, don't make it a boring session. Come on. So I'll start with picking up the questions now. Garcia, any question? Why you are thinking? Come on. Beta, see, if you are missing this opportunity, you are actually to be blamed off because you won't be getting insights of AI. AI is a very interesting and very, a landmark topic which is being running throughout. So if you have any questions, you may please go ahead. Besides using your Instagram and Snapchat here.
Dev sir, all of us are there, even except AI, they can ask us any general question.
Any general question? Career insights of law? Any question?
Career Insight, Sonu has a question. Sonu has a question, Dev sir.
Sonu?
Huh.
Very good, Sonu. Adi Sonu, your question should be in English.
My question है भी मतलब ये AI वगैरह जो है कि वो भी मतलब रिश्तियां के खिलाफ कितना को हो रहा है रिलेशनशिप के खिलाफ कितना को हो रहा है कि रिश्तियां के खिलाफ जिवें ਆਪਾਂ ਕਹੀਏ ਵੀ ਇੰਸਟਾਗ੍ਰਾਮ ਕੋਈ ਵੀ ਆਪਾਂ ਚੈਟ ਕਰਦੇ ਆ ਨੋਨ ਪਰਸਨ ਨਾਲ ਬਟ ਆਪਦੇ ਫੈਮਿਲੀ ਨਾਲ ਆਪਾਂ ਨਹੀਂ ਵਰਤਾ ਕਰਦੇ ਉਹ ਜਿਹੜੀ ਹੈ ਬੈਟਰ ਕਰਦੇ ਤੇ ਉਹ ਵੀ ਮਤਲਬ ਉਹਨਾਂ ਵਿੱਚ ਵੀ ਮਤਲਬ ਵੀ ਇਹ ਭੇਦਭਾਵ ਹੋ ਰਿਹਾ ਜਿਹੜੇ ਹਿਸਾਬ ਦਾ ਵੀ ਬੰਦਾ ਆਪਦਾ ਵੀ ਮਤਲਬ
कोई ये पूछ
गुस्सा कर गया
कि हम अपने आप को इम्पैक्ट ऑफ सोशल नेटवर्क ऑन
So, Sonu, what you mean is that you do not spend time with your family, you keep on using these social media sites.
Yes.
So what can AI do in this? Can it come and stop you from not using? What is AI, Sonu? What is AI?
मैम वो चैट जीपीटी हो गया ਹੁਣ ਆਪਾਂ ਜੇ ਗੱਲ ਕਰੀਏ ਜੇ ਮੈਨੂੰ ਕੋਈ ਪ੍ਰੋਬਲਮ ਪੈ ਗਈ ਆਪਾਂ ਚੈਟ ਜੀਪੀਟੀ ਤੇ ਵੀ ਮਤਲਬ AI ਆ ਜਿਹੜਾ ਉਹਦੇ ਤੇ ਕੁਐਸਚਨ ਪੁੱਟ ਕੀਤਾ ਉਹਨੇ ਝਾਟ ਆਨਸਰ ਦੇ ਦੇਣਾ ਮੈਂ ਵੀ ਐਦਾਂ ਨਹੀਂ ਐਦਾਂ ਕਰਨਾ ਐਸਟ੍ਰੋਲੋਜੀ ਦੇ ਵੀ ਉੱਥੇ ਪੈ ਜਾਂਦੇ ਆ ਸਾਰਾ ਕੁਝ
Astrology?
ਮੈਮ ਉੱਥੇ ਪੈ ਜਾਂਦਾ ਸਾਰਾ ਕੁਝ ਸਨੈਪਚੈਟ ਵਗੈਰਾ ਤੇ AI ਤੇ मतलब ਉਹਨਾਂ ਚੀਜ਼ਾਂ ਦੇ ਕਾਫੀ ਨੈਗੇਟਿਵ ਪੁਆਇੰਟ ਆ ਮੈਂ ਟੋਟਲੀ ਡਿਸਐਗਰੀ ਹੈ
No, you are right. All these social media sites do not let us spend time with our family. This is wrong.
Good question, Sonu. What is the negative impact of AI in daily use?
Negative impact of AI in everyday use is way too much because anything that you are creating now, for example, if you wish that if you are in computer engineer, mechanical engineer, right, you want to come up with something, you are already practicing that, you are already working on that, but during that period somebody steals your idea that you are working and generates that with the use of AI because AI can work comparatively better and faster than you because that is a computer generated thing. So obviously you will get impacted out of that because if that will come first then you will not get IPR protection under that because there is no novelty in that. So AI is impacting our lives. You cannot say it is impacting us every day, but what all new we want to do, it is impacting us in all those ways.
Okay, thank you, ma'am.
मैम एआई के मतलब हमारी लॉ फील्ड में पॉजिटिव और नेगेटिव इम्पैक्ट
I will tell you. And we are talking about the positive points. Now, tomorrow, if you are going into some new field, right? For example, if you want to explore the arbitration law, right? Because that AI is a machine which is giving you answers as human interact. Right, so the whatever you will get the answer as per your understanding will be based on whatever laws we have, right? But AI is something that is going to search for the international laws also, national laws also, and in a summary they will answer you something, right? This is the positive point where you can research more, your R&D can be more. Now when it and we have talked about the IPR, right? IPR is intellectual property rights. Copyright infringement is there. You have copyright, somebody else is using. You have a patent on somebody else is using. Same goes for the trademark. So if we make AI so strong that it can catch the infringement within seconds, so this is an advantage of AI. Right? When we talk about the disadvantages of AI, disadvantages basically now drafting can also be done through AI. So tomorrow you are going to be budding lawyers. Don't you think your profession is going to be affected by that? If everything is going to be done by AI, so why are people going to give you so much fees?
Ma'am, how can AI overcome in the litigation field?
How can AI
Reduce the litigation field?
over reduce? See, we will not come to this point how to reduce the use of AI. We are discussing about AI, something that is very beneficial. And it is not today, it has been a lot of time since then the AI has started its use, but now because chat GPT has come and everybody is using it and it is working more than a human can work with the same intellect. That is why we are talking about AI. We do not need to reduce AI, we need to get protection over that AI. We need to have somebody responsible for the actions done by AI. We need not to reduce it because in the coming times technology plays a vast role. India is although one of the countries which has come on the top list of technologies and advancement, but protection is required.
The basic insight that I got was that it's an app of facilitation. It facilitates.
True.
And AI has still not got the human emotion, but law is basically about the human emotion. So how can we label any copyright or grant that copyright or even the value to AI such a way that it will get ultimately the copyright, because ultimately it is run by human. It is an app of facilitation, not distinctiveness or creating something which is something new out of the book.
So your question is that you do not agree to this thing that protection should be given. Are you agree? You do not agree to it.
No,
Now, whenever AI is coming up with some thing new, how does AI come up with something new? Is there any coding that is being done? Is there any data input that is being done? That is done by the persons as well, humans as well. If they do not do that coding, if they do not put anything, how will the AI generate anything? There is a difference between AI and there is a difference between AI generated works. AI is an application in itself that works. AI generated works are the instructions given by humans out of which AI comes out with something. So protection is required.
Ma'am, my question is how we can see human activity and AI working together?
How we can say human activity and AI is working together? Without the human intervention, how do you think that AI is going to come? Now we are saying that there are robots who are going to work like persons. Who is giving them coding? Who is giving them the content to work upon? Until and unless there is no human intervention. See, IPR is conflicting because IPR says that we will give protection to the people, to the human who is giving us something. Here humans are working on something that is an artificial intelligence, and that AI is coming up with some data to us. So automatically the humans are linked to it. Humans only came up with this AI. Humans only thought that when we will do this coding, when we will do all this data input, then only this AI can create something for us. So without the human intervention, it is not possible.
My question is how the human activities together, how they work together.
How they work together, this is what I'm telling you. For example, you have Siri. Right now Siri works on iPhones. Somebody might have given them some content, then only Siri works like that to you. So here the question is, here what we are discussing is that AI is doing its work, that is okay. But AI is also working because the humans have given them instructions. If the humans would have not told Siri how to work, no coding would have taken place, then what would they have done? How would have Siri worked? So humans are playing a major role with the AI. Coming up of AI is a result of the humans. It is just the computer field. AI has come from a computer generated field.
The future of IPR evolving,
with the rise of the AI like ChatGPT, Gemini, and Siri?
See, if we talk about the future of IP, there is nothing to do with the future of IP because IPR is working very well in terms of their laws. What we need to question is, like we studied in the last slide, there are countries like Hong Kong, US. They are saying that computer generated works can be protected under copyright. So automatically copyright is also going to go, AI is also going to grow, and the person who has worked behind that AI is also going to grow. There is nothing seeing the future. Only the thing is that laws should be made in combination of the AI so that ultimately the person can benefit out of this and work on the AI generated works.
Can AI detecting in IPR infringement compared to human experts? Then it is yes. So is it reliable?
Yes, AI is reliable. Now again, what your question is basically that tomorrow when we talk about the advantages of AI, so can AI detect infringement? This is what your question is. It will be able to detect infringement, and that too within a very less time. Because it is a machine that has been working. If for example tomorrow you go and file a case of infringement, so they are going to open their history, they are going to open their documents, and then they will search, but AI will do it within seconds because it will have all the data.
Now, what is the biggest risk in the development of AI?
Human employment. Human employment is coming at a risk because, as I was discussing with you, our profession only. What is our profession? Tomorrow you go to the courts, any client that you get, first thing comes is the drafting. If the drafting is going to be done by AI, so why is the client going to pay you so much? And it is not about being only drafting. The robotics that are being created there, they can even argue, they can even speak like humans. And being into litigation, our work is only getting into those things. So AI is a threat. But we cannot say that reduction of AI should be there because AI proves to be, very beneficial in other activities as well.
So that means human intelligence is on the top.
See, human intelligence is on the top. That is why we have the AI. If humans would have not worked, then how would the AIs work? But here the problem is, you might be aware that there is a lot of funding being done by the startups, by the government. Now those things will come to a halt because people might take a lot of time to come out with something that is inventive and different with some authorship rights in that. But since we have AI, so automatically those things come to an end. Research can be done quickly. Before we come up something that needs to be protected under the IP law, it has already been done by the AI. So there are certain risks that it possesses as well.
How can AI different from mind?
Huh?
How can AI different from mind?
How is AI different from mind? See, AI is basically replacing the humans. What all work the humans can do, the same way AI can also do, but since it is a computer generated work, so it can do it faster.
But mind, according to mind, आप isn't track कर सकते.
Track.
Track मतलब totally मतलब अपना mind use करके, but AI ने use करना होता है.
Because AI can do it faster. We are living in a world of technology advancements. Why do you use laptop to write? You can write it down on a paper also. So no. All right. Shivam, question.
AI does do have any kind of a biasness?
AI doesn't have any kind of biasness. It is based on whatever instructions are being given.
Okay.
So one basically my doubt is like a country like India, overpopulated country. So what do you think like AI can grab all the opportunities of the lawyer in country like India?
See, what is the meaning of grabbing any opportunity? AI is doing what you are telling them, what you are telling AI to do. See, you search any topic on ChatGPT. Does it say it is unable to answer? It answers all your things. So it is not that it is a populated country. It works like a machine. It works like how any human brain works. It just works faster with more technology in it.
No.
Yes, Falak, any question?
No questions at first. Palak, you have a question? Great session, by the way.
Thank you.
Since you mentioned that AI might take up our jobs, well,
what I was wondering was, what if AI becomes smarter than us? What should we do then?
See, when it is taking our jobs because it is becoming smarter than us. It is becoming smarter than us. And you won't believe when laptops came into the picture, when computers came, so people used to think that how will I work? There is a lot of advancements, how will all these things work? But when the computer came, laptops came, how did the IT sector boom up? So what we are talking about is, since we are talking about the disadvantages and pros and cons of AI, so then we say that till date it is a threat, because tomorrow if drafting is done by AI, if tomorrow you give them the instructions and then the AI comes up with something that is perfect, but in that case you should get acknowledgement for that thing. That is what our basic discussion is. That what all is even done in AI is ultimately the result of human brains, human interventions. So at least they should be acknowledged from them.
जो infringement हो रही है laws की, वो protected होनी चाहिए. तो मैम अगर कोई Google में हम कोई information डालते हैं, कई बार वो भी हमें कोई गलत information दे देती है, तो who will be responsible?
This is what the question is. As I told you, for example, this fan is made out of AI. Right? Tomorrow if it falls or something wrong happens, who is liable? We are not saying anybody liable because we are not giving any rights to that person. Have Google anywhere said you, is there any agreement which says that Google can never provide you with something that is wrong? So neither if Google gives you a wrong response, the maximum you can say is that it is giving us wrong responses. But no action can be taken against it because that person is not held liable for it. If we are saying that if this has been created by the AI, so the right should be given to the person who has done the coding out of which this content has come, so that we can hold him also liable. But until and unless we are not giving them rights, so we cannot hold them liable also. It is not once. Google Maps, how many times it tells you the wrong way? What can you do in that? You cannot do anything, because they are not giving rights to anybody, so nor can you even hold anybody liable for that has been done.
Anyone else? No?
Kumbara, any question?
He's busy sleeping. Anybody?
Sachi, any question? Alright, so
Thank you, Aishwarya ma'am, for providing us all the insights related to AI and IPR. And we wish that these coming more lectures should be more enriching and insightful. Thank you to our beautiful audience, although you have not asked any questions. But certainly, yes, it was a very insightful session. Thank you so much, ma'am.
Thank you,
Thank you.
sir.
Thank you, everyone. You may please get back to your classes. Thank you.